Good afternoon, everybody. My name is Joshua Filani. I'm a legal intern at the Immigration Project. And today I'll be sharing the Immigration Project's presentation about the Bonafide determination process of the USCIS regarding U visas that recently was updated a couple of months ago. To start with, we will be looking at the U visa Bonafide determination process from 6 parameters. The first one is what is a U visa? The second one is who is eligible for a U visa? Number 3 would be how to petition for a U visa. Number 4 will be just a brief history of what happened with respect to U visas before the Bonafide determination policy update. Number 5, we'll dive into the Bonafide determination process, and we will talk about what it means for U visa petitioners today. Number 6, we'll be informing everybody about what the Immigration Project is doing with respect to this new update. Without wasting much time, I'm just going to get right into it. So first thing we need to know is that U visa is a non-immigrant visa that is issued by the United States pursuant to Section 101, Sub 15U of the Immigration and Nationality Act. So the U visa is a type of visa that allows a non-citizen who has suffered physical and mental abuse by virtue of being a victim of a crime to get visa benefits in the US. So basically, if you've been a victim of a crime and you've suffered physical and mental abuse, you will be eligible to receive a U visa in the US. The lawmakers who passed this law had the intention of using this visa benefit to promote the ability of law enforcement agencies to investigate and prosecute crimes. However, not all crimes qualify for U visas. When they passed this law, the major focus of the crimes that they intended for purposes of the U visa application were domestic violence, sexual assault, trafficking, and some other ancillary crimes to that. The intention is to protect the victims who have suffered physical and mental abuse as a result of the crime, as long as they can help law enforcement officers to investigate and prosecute the said crime. So you must understand that for a U visa, you must have been a victim of a crime that has made you suffer physical and mental abuse, and you must be willing to help law enforcement in the investigation and prosecution of that crime. So the next one is who is eligible for a U visa. Primarily, any non-citizen who has suffered substantial physical or mental abuse as a result of having been a victim of a criminal activity is eligible for the grant of a U visa. However, as I said before, not all crimes qualify for the grant of U visa status. We'll go briefly into the crimes that qualify in the next slide. The first crime we see here is abduction. You have abusive sexual contact. So if you've been abducted before, you will be eligible to receive a U visa status if you apply. abusive sexual contact. If you've had abusive sexual contact with anybody, you would or you should be eligible to receive U visa status. If you've been held hostage before, if you've been blackmailed by anybody before, if you've been extorted, if you have been imprisoned against your will, if you have been assaulted, beat up violently, if you're been mutilated in any way, if you've been victim of fraud or incest, or you've been forced to serve somebody else against your own will, or you've been kidnapped, you will be eligible for the grant of EU visa status. Other crimes include victims of manslaughter or attempted manslaughter, murder, obstruction of justice, peonage, perjury, prostitution, attempted rape, sexual assault, slave trade, stalking, torture, trafficking, unlawful criminal restraint, witness tampering. If you've been the victim of any of these crimes, you would be eligible for EU visa status. However, there's one that baffles me a little, which is the murder case. If you've been a victim of murder, you're probably not alive to tell the story and get EU visa status. So that's a bit complicated, but you get the general picture though. So who is eligible for a EU visa? As I said before, if you're a non-citizen who has been a victim of any of the crimes that I listed in the previous slide, you will be eligible for EU visa status if you possess information concerning the said crime and you're being helpful to federal, state, or local law enforcement officials investigating or prosecuting the criminal activity. Now, you must note that for this crime to fall under, for it to be qualifying, it must have occurred in the United States or violated some US law. So if, for instance, you were, your client has been a victim of sexual assault that did not happen in the US, it may be difficult to be a beneficiary of the EU visa status. However, it is against the US. If this crime occurred in the United States, then that victim should be eligible for EU visa status. However, the victim must be ready to provide information regarding the criminal activity to law enforcement agencies, whether it's federal agencies, state agencies, or local enforcement agencies, or even the court, if there's a contentious trial and there's need to give evidence. In that situation, there will be a need for that victim to be granted EU visa status so that they can help in the investigation and prosecution of the said crime. Remember, as I said before, that for the grant of EU visa status, the most important thing is that, and the most important intention of the legislators when they created the law was to help local, state, and federal law enforcement agencies prosecute and investigate crimes. So if you're not ready to help the law enforcement officials prosecute and investigate crimes, you most likely will not be eligible for EU visa status, even if you've been a victim of any of these crimes. So 3, we're going into petitioning for EU visa. The petition for EU visa is form I-918. In order to be eligible for the grant of U visa status, that form must be filled, signed, and deposited with the USCIS, that's the United States Citizenship and Immigration Service, for their consideration or approval. So the USCIS is the body that considers and approves U visa applications. I said before, the USCIS stands for United States Citizenship and Immigration Services. U visa form is called Form I-918. And in order to apply, you have to fill that form and submit with all relevant documents to the USCIS. The relevant documents would include a certification from a federal, state, or local law enforcement official, maybe a prosecutor, a judge, a police, a sheriff, the FBI, basically any law enforcement agency, the DEA, that is ready to certify that this victim is helping us in the investigation or prosecution of this said crime. So you would have to provide a certification from that law enforcement agency stating that you're being helpful to the investigation. In considering the petition for U visa, you must also take note that the fact that you're not resident in the United States does not prevent you from being eligible for a U visa. As I said before, as long as the crime is committed in the United States, or the crime committed, even though it was not in the United States, has violated some US law, and you're being helpful to any law enforcement agency in the prosecution or investigation of that crime, you will be eligible for the grant of U visa status. Also note that U visa applicants under the age of 21. So if you're 18, you're 19, you're 20, you're 17, you have a right to include your derivatives in the petitions. By derivatives, you mean your family members, spouse, parents, other married siblings were under the age of 18. You can petition for them too, and everybody will be granted U visa status based on the strength of your own application. Also take note that when you are granted U visa status, you're authorized to work in the US, as you're automatically given an employment authorization document that lasts for the period of your U visa status validity. So if you apply, you petition for U visa by filling the forms and attaching the certificate from the law enforcement agencies and all other documents, you would also have to fill and sign the employment authorization petition. And if your application is successful, you will be granted employment authorization document, which grants you the right to work and earn a living in the United States. And this would also apply to your derivatives too, if you have derivatives. If you're over 21 years old, you can include your spouse or your children that are under 21 years. If you're younger than 21 years old, you can include your spouse, your children under 21 years, your parents, or your unmarried siblings under the age of 18. In petitioning for a U visa, you must also know that there is a time constraint with applications. And to that extent, a lot of applications don't get approved on time. However, that doesn't mean that you would be out of status if you applied for U visa and you were living in the United States. It would just mean that you will not get your employment authorization on time, and that may prevent you from earning a living in the US. So before the bona fide determination update that the USCIS released a couple of months ago, there had been a very huge backlog of U visa petitions, and there still is a very huge backlog of U visa petitions today who have applied several years ago and still not obtained their U visa applications and their U visa status. This was because the Immigration and Nationality Act put a cap of 10,000 issuable U visas every year. So what the Immigration and Nationality Act basically did was make sure that the USCIS cannot issue more than 10,000 U visas every year, irrespective of whatever amount of people apply. So if 1 million people apply in 2021, the USCIS would only be able to issue just 10,000 visas. And this is irrespective of if they're all eligible. So it doesn't mean the fact that the USCIS was not issuing the U visa statuses to them did not mean that their applications were rejected because they were eligible. They just had to be put on the wait list. So what happened was that, sorry. So what happened was that the USCIS would issue 10,000 U visas and put the remaining 990,000 people on the wait list for the coming years. That created a huge backlog, and people had to wait as much as 5 to 10 years to get their U visas issued. So the fact that you were eligible did not mean that your U visa would be issued immediately. Most petitioners, as I said, had to wait for 10 years. Some people even waited more. And as of today, just for context, it is estimated that there are over 100,000 cases, because as of 2016, we already had 67,000 pending U visa applications that had not received status, even though they were eligible. So this was a huge problem. This was a huge problem both for the USCIS and for all the parties involved, because the implication meant that when you apply for a U visa, you cannot work because you do not have authorization to work, right? And pending the determination of your U visa application, all you would do is just sit down at home and do nothing. Or you try to make a living without working in the US, even though you live in the US. And that created a lot of problems because a lot of these petitioners will not be able to get any employment irrespective of the fact that they were helping law enforcement prosecute and investigate the crimes that they had been victims of. So it was a huge problem for a lot of people. Remember, I said that your U visa application automatically, if successful, automatically gives you the right to work and earn income in the US. So until that determination, you have no right to work or earn income in the US. That was a big problem. Yeah, so this slide basically just recaps what I said. So the ripple effect was that applicants had to wait several years, could be 5, 10 years or more, for their application, for the approval of their petition. And this meant that they couldn't work or earn income legally, even though they were residing in the United States. And this brings us to the bona fide determination process. The bona fide determination process, which is the most important thing that we would learn today, besides all the other things that I have said. So bona fide basically means in good faith or without fraud or deceit. Um, so when the USCIS defines bona fide as basically stated that if you're applying for U visa status, you're applying in good faith because everything you're saying is true and you're indeed willing to help law enforcement, and it is without fraud or deceit. So it's basically the same thing, meaning that you haven't lied, you haven't fabricated any false stories, you haven't you aren't trying to deceive the system into getting U visa benefit when you do not deserve it. So that's what they mean by bona fide. And what the implementation of the bona fide process does is that it allows eligible qualifying U visa applicants to work and earn income in the United States pending the final determination of their U visa application. Remember that I mentioned that prior to the bona fide determination process, what happened was that when people applied for U visa status, they would not get any work permit. Basically, they had no employment authorization card that allowed them to work and earn income in the US until the final determination of their U visa status application. And that could take as much as 10 years because of the backlog of people that who applied before them and who were still on the wait list because the USCIS cannot issue more than 10,000 visas per year. So the bona fide determination process basically allows people who are eligible but unfortunately stuck on the wait list to be able to work and earn income pending the final determination of their U visa status application. So the process basically goes, you've been unfortunately a victim of a crime, you suffered tremendous physical, mental abuse. The crime was committed in the US or violated US law. You file your form I-918, you provide your certification from law enforcement officials who will be investigating and trying to prosecute the said crime and need your assistance, which you have been freely given to them. You fill that form, attach the certificate, your employment authorization form, and other ancillary documents. You file that with the USCIS, and you're put on the wait list pending the final determination of your application. However, the bona fide determination process now allows the USCIS to issue you work employment authorization that would enable you to work and earn income pending the final determination of the visa application. So this is a recap of what I just said. After you filled the form I-918 and all ancillary documents, you would also attach a personal statement describing the facts of the victimization that you must have suffered because of the crime that was committed. That statement of facts would include the crime, the efforts that were made to help the law enforcement officials, as well as the trauma that you suffered from that crime, which is the mental, physical trauma that you suffered from the crime. And then the USCIS will check everything that you've said to confirm the veracity of the story that has been given to them. They do background checks and checks with the security agencies and do biometrics. Basically, pull out your records to be sure that what you're saying is bona fide. If the petition is deemed bona fide, the USCIS will then determine if petitioner poses a risk to national security or public safety. So it doesn't just end that your petition is bona fide. The USCIS still has phase 2, which is after determining that your petitioner is good, they also have to determine that you are not a threat to national security or public safety. So if, for instance, you are a threat to national security and everybody wants to kill you, and you're a threat to public safety because people are afraid that, oh, they're going to bomb someplace because of you, and that place will be in the US, it may be difficult for the USCIS to determine that you're entitled to U visa status. However, if these two conditions are successfully fulfilled, the USCIS will issue the BFD employment authorization document, which I call the Bonafide Determination Employment Authorization Document, BFD-EAD for short. And that basically would allow you to be able to work and earn income in the United States pending the time, pending the final determination and issuance of the U visa application that you filed. And as I said, that would only be dependent on when the wait list gets to your turn. So if the USCIS had 64,000 people on the wait list in 2016, and they can only issue 10,000 people a year. So if somebody filed in 2016 and is amongst the 10,000 people who filed in 2016, they know that all the people who filed in 2016 will not be eligible for final determination of the U visa application for the next, at least for the next 6 years, because it's 10,000 per year. So if 2016, 10,000 people were issued U visas, 2017, another 10,000, 2018, another 10,000, 2019, another 10,000, 2020, another 10,000, 2021, another 10,000, then maybe the person who filed in 2016 will be eligible in 2022. However, and you can see that that causes a very big problem for the petitioner, because that would mean that they wouldn't be able to work. But the bona fide determination process allows that problem to go away, because at this point, they will be issued employment authorization documents, which allows them to work and make money in the US. That would also enable them to get a social security number. That would also enable them to access to credit, access to anything that they probably need to live a good life, which was not what was happening a couple of years ago, months ago, as a matter of fact. And also, you must note that the import of the BFD-EAD means that petitioners will be granted deferred action for the period of the period that the BFD-EAD is valid for. So deferred action basically means the USCIS or the immigration enforcement bodies will not try to put you in removal proceedings, even though you do not have your U visa status. So indirectly, you will technically not be out of status, even though you do not have status, right? So once you get that BFD-EAD, you have deferred action, which means you will not be put in removal proceedings at this point until the expiration of your BFD-EAD, or if your U visa application gets revoked or gets denied for whatever reason. The time for the EAD and the deferred action is usually 4 years. However, it can be renewed for another 4 years. So if, for instance, you filed in 2016 and you've not gotten your U visa status yet, and this is 2021, you could apply and then you'll be granted a BFD EAD, that's an employment authorization document for the next 4 years, along with deferred action. If your U visa application is still not determined after the expiration of those 4 years, you will be eligible for another renewal for 4 years. And that helps people who are on the wait list to continue to lead their lives the best normal possible way. So now that the USCIS has updated the visa policy and introduced the bona fide determination process, U visa petitioners can now work pending the determination of the petition, which is a very good thing. So which brings us to the final point of this presentation, what the immigration project is doing and how you can benefit from it. At the immigration project, we have a long history and we have a number of clients that we have been working with over the past years. We have, of course, been filing U visa petitions for a while now, and we have a number of clients who have not been able to work or earn income because the U visa petitions have not been granted yet. At this point, what we're doing is we're going to ensure that the client has filed every part of the petition that needs to be filed, and that the employment authorization form, which is from I-765, has also been filed, because that would be the official request for an employment authorization, which ordinarily would not come until after the grant of U visa status. That's after you get your U visa certificate. However, because now you don't need to wait to get your U visa certificate before you get employment authorization, you would file your employment authorization along with your U visa petition, which allows you to get your employment authorization card if the USCIS determines that your U visa petition is bona fide. If we discover that any of our previous clients are yet to file the 765, what we do is that we fill in the file and submit it with the USCIS so they can be deemed eligible for the BFD EAD, bona fide determination, employment authorization document. What this does is this helps our clients to earn legitimate income pending the final determination of the U visa petition. As of today, we have compartmentalized all our U visa cases, and we have begun to fill and file Form 765s for all petitioners who were previously yet to file theirs. Well, once we're done with this, we will await the USCIS decision regarding whether to consider the U visa petition as bona fide. Once they consider it as bona fide, they would issue the employment authorization document, and the same document will be forwarded to the employment authorization safe address while we await the final determination of the U visa petition. So what this process basically connotes is that once we file the 765, which is the application authorizing that U visa petitioner or applicant to work in the US, we will await the determination of the USCIS regarding the bona fide eligibility of the U visa petition itself. Once that is positive, we would receive the BFDEAD, which would allow the U visa petition to work pending determination of the U visa petition. So just a repetition of what I said before. And that brings us to the end of this presentation. While we must commend the USCIS for the initiative in making life easier, I believe there's still a number of things that can still be done to make the process more seamless for U visa petitioners. Like maybe changing the law itself and not limiting it to just 10,000 issuable U visas every year. That would be a very great step to start from. Thank you very much for taking our time to listen to this presentation today. We're here for you and we're here to help you. And if you need anything, do not hesitate to contact the Immigration Project through our website. Thank you very much and have a good day. Bye.